On May 12, 2025, the Federal Court of Canada set aside a refusal decision issued by IRCC, finding that the visa officer had failed to properly assess the applicant's family ties in her home country. This wasn't just a paperwork error. It was a breakdown in how the evidence was weighed, and the case serves as a clear example of how flawed reasoning can undermine an otherwise well-supported application. The case involved a woman from Iran who applied for a study permit to attend a program in British Columbia. Her husband and teenage daughter applied to accompany her, a step that is both permitted and anticipated under Canada's immigration rules for international students. The application included detailed evidence, such as full payment of tuition, a formal 2-year leave of absence granted by her employer, a written offer for a job promotion upon return to Iran, property ownership and financial assets in Iran, and documented family ties, including the applicant's parents, siblings, and the spouse's extended family, all still living in Iran. Despite this, the officer refused the application. The core reason? The officer concluded the applicant and her family didn't have sufficient ties to their home country, primarily because they intended to travel to Canada as a unit. Justice Simbaris of the Federal Court disagreed with that conclusion and granted the applicant's request for judicial review. While the court acknowledged that the officer was entitled to consider the pull of being in Canada with one's family, it emphasized that this must be balanced against the push factors. In this case, the applicant's established ties to Iran. These ties weren't minor. They included not only immediate family, but economic and professional roots. Instead, the officer's notes appeared to stop the analysis after stating that the applicant would be accompanied by her spouse and daughter, described as immediate family. There was no meaningful engagement with the other side of the record. In paragraph 18, the court noted that the officer considered the pull towards staying in Canada, but did not consider the push factors towards returning to Iran, and did not complete the weighing analysis. This isn't an isolated case. Canadian courts have repeatedly cautioned against treating the presence of family members in Canada as a standalone reason to refuse a visa. In Jafari v. Canada, the federal court found it unreasonable to assume that an applicant traveling with their spouse would never return home, especially without addressing the applicant's specific circumstances. In Amalshi v. Canada, the court stated that officers must clearly explain why the ties submitted, including family, property, and employment, are insufficient. Simply asserting that the family will all be in Canada is not enough. And in Vadati v. Canada, the court noted that Canadians frequently study abroad with their families. A similar plan by a foreign national shouldn't automatically raise red flags, particularly when Canada's immigration regime allows students to bring spouses and children. In this latest case, the officer failed to explain why the family's ties to Iran, including multi-generational relatives, property ownership, and a pending promotion, were not enough to indicate they would return home. The refusal lacked a rational chain of reasoning, and when that happens, the federal court can intervene. If your application was recently refused and the decision doesn't reflect the actual facts you provided, it may not be the end of the process. Under Canadian law, some refusals can be challenged through a judicial review application. But these applications are time-sensitive, and success depends on identifying specific legal or procedural errors in the decision. If you believe your case was unfairly refused, speak with a Canadian immigration lawyer to assess whether a legal remedy is available.